What can you do with the power of attorney? This is one of the most important tools in an estate plan. It gives the power to somebody else to make financial decisions for us if we are incapacitated. Incapacitated just simply means that you are not able to manage your finances or your matters on your own. In court, there's a legal definition for it. Generally, in the power of attorney, it's defined. Power of attorneys can either be granted immediately or after a letter of incapacity or some other triggering event. These power of attorneys are called springing power of attorneys. A lot of times people are wondering what exactly they can do with this document when faced with a loved one who has incapacity. And the answer to that lies within the document itself. So in general, again, power of attorneys are designed to permit another person to make financial decisions for us. That can be everything from managing day-to-day expenses and billing. It could be things like selling the house, accessing 401ks, accessing annuities, helping us pay taxes. But in order for me to tell you what the power of attorney allows you to do, we have to look at the document itself. There's some important people in the power of attorney, the first being the agent, and that is the person that has been given the power to do things on the principal's behalf, the principal being the person who signed the document in the first place. Oftentimes people think that the ability to do things on behalf of somebody else, such as, bank, is just generally allowed because of the relationship they have. Unfortunately or fortunately, that's just simply not true. If a spouse is not a joint owner on an account with you, they might not automatically or will not automatically be given the ability to access that bank account, even if it's for your interest, absent a power of attorney or some other authority that you've given to them at the bank for that specific asset. It's important also to look at the power of attorney and see if it allows a general sense of assisting somebody, or if it's limited to just certain circumstances or certain times. That is generally called a limited power of attorney. We also want the power of attorney to be durable if we're working with somebody who is incapacitated, because durable simply means that this power of attorney is good now and even when the person becomes incapacitated. Again, that's really when we want it to work. It's also important to note that all of the agent's authority under the power of attorney go away when the principal dies. So the power to access bank accounts after a person passes are not allowed in a power of attorney. That is where in a estate plan, typically through will and probate, or if there's a trust involved, that's where those documents take over. Also important to note that a power of attorney cannot access a trust account. If you have a revocable living trust, usually it is the trustee who manages the trust. Oftentimes we should always appoint a successor trustee in those trusts. That successor trustee is who would step into position of trustee in the event of incapacity. So again, trust, power of attorney, these typically will cover financial aspects. We have to go to the document itself to figure out exactly what the agent is entitled to do, when the agent is allowed to come in and help. Hopefully this was helpful, and tune in again for another episode.